Morning, ladies and gentlemen. Can you hear me? Excellent. Well, an awful lot of you have turned up to hear me pontificating about the relationship between regulation, disciplinary action, and duties of care, and I hope you won't be disappointed. On the front page of this morning's Financial Times, there is an article which says that the United Kingdom has the slowest rate of approval of nuclear power stations of any country in the developed world. And for any of you who have ever done a case involving nuclear approvals, you will know that the vast amount of money which is spent in relation to that is not spent on actual physical activity. It's spent on endless rounds of engineering time, whereby people prove that in, for example, the west coast of Scotland, where we put our nuclear submarines, if you have an earthquake and a storm at the same time, there won't be a problem whereby you get the nuclear submarines without power and sadly then causing rather large amounts of pollution on the west coast of Scotland. That is, of course, an argument that we regulate too much, or at least inefficiently. Yesterday, I was reading an article which was saying that we needed to introduce a new offence of cycling on the pavement, pausing for a short matter that all of you know that cycling on the pavement is actually an offence already, and that the problem is not that there isn't an offence, it's merely that for whatever reason it doesn't get enforced. It then suggested that we should introduce driving licences for cycles together with compulsory insurance, thereby suggesting that we are under-regulated. Now, this country, unlike our French neighbours, doesn't really do philosophy, and we don't really tend to think very hard about what the proper role is of regulation and what the relationship should be with other mechanisms to achieve socially desirable outcomes. I would suggest this talk is going to focus on one very narrow aspect of an enormous subject, which is the relationship between regulation, professional discipline, and duties of care at common law. And I would suggest that that is a very, very small part of a much wider subject. But it does seem to me that in relation to any kind of regulation, one needs to start off with saying how important is the aim. Stopping people burning to death might be thought to be more important than making sure that a building is adequately insulated. Stopping solicitors from stealing money from client accounts might be thought to be more important than ensuring that solicitors who drive whilst drunk can no longer be solicitors, especially given the fact that they will already be subject to sanction at the criminal law. The second question, which is very rarely asked, is what are the consequences of not regulating? The third, are there any existing regulations which already cover the matter? If so, why are they not achieving their aim? Why are people cycling on pavements? Well, because the last time someone was prosecuted for cycling on a pavement was probably in the Middle Ages. What are the financial and other costs of regulation? All of us, I think, are aware through our professional memberships of increasing costs of regulation. We are aware through working for insurance companies that insurance companies now employ people in order to do two things. One, go through our bills with a tooth comb with the age of AI in order to spot possible discrepancies to see whether or not they have an excuse for not paying us. And secondly, to employ people to do things like decide whether or not our travel policy is or is not compliant with the obligations undertaken by the country as a whole in the last round of climate accords. Are there other more effective ways to achieve the aim? And how do you ensure that there is not mission creep? Just a word on mission creep. Regulators given half a chance don't tend to concentrate on that which is most important. The SRA didn't stop Ince & Co. from having very large amounts of money coming out of a client account despite the presence of numerous warning signals. On the other hand, prosecuting people who have already been found guilty for drunk driving is easy and cheap. The fact that one might be thought to be much more important than the other doesn't appear to occur to the SRA. The Bar Standards Board might be thought to want to concentrate on prosecuting incompetent or dishonest barristers. Instead, at the moment, it's indulging in a campaign to see whether or not the buildings within the Inns of Court can be made more disability compliant. That is despite the fact there is already an Act of Parliament to which the Inns of Court and all other buildings are subject, which covers the relevant matter. But it appears rather easier to concentrate that on other matters. Now, all of these questions, it seems to me, involve a relationship with the common law, because what I will be suggesting is that on some occasions, the common law has restricted itself from intervening in particular areas, even though it would do a rather better job than the regulators are doing. If one looks at the traditional attitude of the common law, I have set out there a quotation from Lord Mackay's speech in Murphy and Brentwood. And he said, in deciding to overturn Anne's, that he was of the opinion that it was relevant to take into account that Parliament has made provision in the Defective Premises Act 1972, imposing on builders and others undertaking work in the provision of dwellings obligations relating to the quality of their work and the fitness for habitation of the dwelling. For this House in its judicial capacity to create a large new area of responsibility would, in my opinion, not be a proper exercise of judicial power. Now, just pausing there, at the time that that sentence was written, the Defective Premises Act had been on the statute book for some 18 years and had been in force for some 16 years. It was universally acknowledged at the time to be a dead letter, and it was a dead letter for two reasons at the time. One was that it had a 6-year limitation period, and so it added really almost nothing in relation to problems in relation to defective buildings where you had hidden defects which then caused danger. The second is that there was a provision, and still is a provision in the Defective Premises Act, for approved schemes. And initially, the NHBC scheme was an approved scheme. And where the approved scheme applied, the Act had no application. In fact, by a little known quirk of, I think, probably incompetence, we actually only pointed it out in the 4th edition of Jackson and Powell. The NHBC scheme was changed in about 1976 and ceased to be an approved scheme. And so people thought that it was an approved scheme for about 14 years when in fact it wasn't. Anyway, no one, in my knowledge, ever sued on the Defective Premises Act. But nonetheless, Lord Mackay put it forward as being a good reason not to encroach upon the liability of public authorities. The consequences, of course, of the overruling of Anne's and the limitation of duties of local authorities and builders for economic loss was that you could only sue a local authority if you actually yourself suffered physical injury or there was damage to other property. You couldn't sue as soon as you found out that you had got a defective building because that was categorized as economic loss. The second case, undertaken at about the same time, or judgment about the same time, is Caparo and Dickman. And as we know, in Caparo and Dickman, the House of Lords made it plain that auditors owed duties to the shareholders as a body of a company, but not to individual shareholders. And the consequences of that is that although there have been numerous claims against auditors, it actually involved a very substantial restriction on claims which would otherwise have been borne. And I want to explore with you a little bit about the consequences of those two decisions. Murphy and Brentwood, decided 26th of July 1990. For some of us, sadly, a little way into our careers. For many of you here, no doubt, a matter of ancient history. Just as a short point, some 35 years ago, and some 32 years before the passing of the Building Safety Act of 2022. The local authorities not liable for economic loss, a concentration purely on physical safety and danger to other properties, and it is acknowledged and indeed stated in the Moorbeek-Grenfell report that one of the effects throughout the 1990s, 2000s and 2010 was the underfunding of the local authorities' building inspectors' departments. And frankly, that was because the chances of anyone actually complaining or suing those local authorities was very very low. And at least the postulate, and I want to explore this with you, that the 30 years or so of cladding which was put onto buildings post 1990, and almost all of that cladding was put on between the mid-1990s and 2017, would not have occurred. There would not have been a Building Safety Act. The Building Safety Act, of course, introducing a 30-year limitation period. I had a client in the United States who said, "You guys are the Wild West over here. You have a 6-year limitation period. You put in a 15-year long stop period, and then you extend it at the drop of a hat retrospectively to 30 years. Are you some kind of banana republic?" And it's a fair point. I mean, it really is a fair point. You then introduce liabilities, not on the original builders who had their liabilities restricted by Murphy and Brentwood, but essentially on anyone in the corporate chain. Well, again, if one was being unfair and looking at this from an investment treaty point of view, that does look like the actions of a less than mature democracy, let's put it this way. Kapara and Dickman decided some 5 months earlier than Murphy and Brentwood, duties owed to individual shareholders. Imagine that the duties had been owed to individual shareholders. There would have been more common law actions. That would have had the sad side effect, no doubt, of increasing the amount of work for people in this room. One possibility is that, well, there would have been no FRC, or at least no FRC concentration upon prosecutions. I will come back to the effectiveness or lack of it of the FRC in a minute. But one of the things about the FRC is that although 2 years ago they imposed record fines of £48.6 million, not one penny of that went to anyone who had actually suffered loss as a result of the incompetent audits. Now, I know there's the odd accountant in this room, and I'm sure some of you must have seen a competent audit, but I've yet to see one. I mean, in auditors' cases, the question is never whether the auditors have been competent. They never have. It's always beyond duty, loss, scope of duty, the fact that it was the director's fault, etc., etc. And one has to ask why these very highly paid people get it wrong so often. I'll come to my theory on that in a minute, but just to give you a short foretaste, it's that they're more inclined to have hundreds of people doing menial work than actually think about what might actually be wrong at the heart of the audit. Now, whether artificial intelligence will be better than audit partners' intelligence has yet to be seen. I don't think it could be much worse, but we will need to watch this space. But the point I'm making is that if the point of the FRC is to increase the quality of audits, my suggestion would be that it has singularly failed. I want to go back a little bit before Grenfell to the Great Fire of London. I could have gone back earlier, actually. The first recognisable building regulation in London was in the mid-13th century, when thatch was banned as a suitable building material for fairly obvious reasons. Just to remind you of some facts, the fire blazed for 3 days between the 2nd and 5th of September of 1666. There were 6 identified deaths, although most historians think that that is an understatement because there will have been other indigent people who weren't counted. 100,000 people were homeless. That incidentally represents over 2/3 of the then population of London, and London was principally concentrated in the City of London. It took Parliament not the 5 years to get the Building Safety Act, but approximately 5 months to get the Rebuilding of London Act 1667 on the statute book. That is actually a remarkable piece of legislation. It's available in facsimile at all good booksellers or on the internet, and it has 40 sections in it. It refers to 4 sorts of buildings. The 4 sorts are effectively 3 different types of terrace building, each one getting bigger and grander, and then what is referred to as mansions for people of, I forget the exact words, but it's essentially wealthy people who don't need to have building regulations. And there are only going to be a few of those. It also restricts buildings to 4 stories, but it allows penthouses, and that act is the origin of the word penthouses, and the penthouses had to be set back from the other 4 stories. So effectively you had 4 stories which had to go up, and the penthouses could sit on the top with better views, better air, and so forth. The buildings had to be of brick or stone. The thickness of party walls was legislated for. There were provisions for the compulsory rebuilding of London within 3 years, and if that did not take place, if there were sites which were left empty, there was provision effectively for a jury to be impaneled to discover why it was that the site hadn't been rebuilt, and if it was found there was no good reason, for essentially compulsory purchase and redevelopment by other people. Wider streets, the first appointment of a building surveyor for the City of London, and that led to the rebuilding of London. That cost, it is estimated, £10 million in mid-17th century money, and that is approximately £37 billion now. That cost was incurred over a period of some 30 years or so, but it shows the level of the trauma which the Great Fire of London was for the UK, London in particular, and the British economy. It's also fair to point out that the taxation provisions, this was not an unfunded piece of legislation. The coal tax was increased by a factor of 4. And that led directly to funding of the enforcement mechanisms and also to the provision for the replacement of certain public buildings, including churches. So what do we get from the Great Fire? Well, first of all, we have to accept that regulation is necessary. Left to itself, the free market leads not only to death, but also to enormous public cost, a lesson which we needed to be reminded of by Grenfell. Secondly, private interests have to be subordinate to the public good in preventing fire. Thirdly, the objectives of the legislation were clear, the legislation was clear, and there was a mechanism for enforcement. Now, no one would, I suggest, say that the Rebuilding of London Act was a perfect statute, but it wasn't bad for something in the mid-17th century on 5 months without an inquiry and without the provision of enormous expense. If we then go forward, We then see what happened so far as statutory control is concerned. Don't worry, I'm not going to take you through each of these acts. But we have the Mischief by Fire Act of 1707. Wooden roofs had to be surrounded by stone parapets. Mischief by Fire Act of 1708. Window frames had to be recessed. Mischief by Fire Act of 1724. Development of party wall control, and so on and so forth. Now, all of these acts effectively ended up being consolidated into what was known as the Building Act of 1744, sometimes referred to as the Black Act. It was called the Black Act by the Victorians because they didn't like it, because it led to the boring uniformity of Georgian squares all over London and a lack of interesting terracotta and the like which the Victorians favoured. This is an example of an act which didn't actually introduce anything very new, but what it did recognise was that the previous provisions for enforcement had fallen into disuse. And it provided a mechanism for enforcing it and raising money to do so. And it also required for the first time the maintenance of firefighting equipment by each parish. It allowed 7 different types of buildings, not 4, and those 7 types of buildings can still be seen all over London in the various different Georgian buildings. And you can look at them if you want, and you can see whether or not a building is a 1st, 2nd, 3rd, 4th, or 5th rate. The other things which were referred to as 1st, 2nd, 3rd, 4th, or 5th rates at the times were ships of the Royal Navy, so that HMS Victory is a 1st rate and so forth. So they were keen on rates in the 18th century. And you'll see the Black Act from the quotation from Disraeli's novel Tancred. Though London is vast, it's very monotonous. All those new districts that have sprung up in the last 10 are the creatures of our commercial and colonial wealth. It's impossible to conceive anything more tame, more insipid, more uniform. Pancras is like Marylebone, Marylebone is like Paddington. All the streets resemble each other. You must read the names of the squares before you venture to knock at a door. Hence the description, Black Act. After that, we trundle through the 19th century, and we start to get introduction of measures to deal with things other than fire. And in particular, I see that I managed to spell metropolitan wrong, I apologise for that. One sees that you start getting provisions for drainage, sewage, and you see in particular revised mechanisms for enforcement. I'd ask you to note that the Public Health Act 1936 introduces mandatory nationwide bylaws. The reason why that is relevant is that it was the Public Health Acts 1936 which were in force at the time of some of the cases we will have a look at in a minute or two. And then we get the Public Health Act 1961, which for the first time introduces building regulations. And the first set of building regulations in England and Wales were in 1965. Those building regulations were really quite prescriptive. They told you exactly what you could do and what you could not do. And they were followed on by the building regulations 1985 and 2010. They also included within them provisions which weren't fire, weren't drainage, weren't that you shouldn't have habitable rooms without light and so forth, but were socially desirable, such as that you required to have insulation for buildings. Now, just pausing there, that is therefore an example of a case where you start off with a requirement for something which is saving health and life, i.e. fire standards. You then go to something which is stopping disease, sewage, and then you go on to something which makes the individual occupants of the building more comfortable, insulation, and also achieves generally socially desirable standards. In other words, the nation as a whole's heating bill is reduced. That is very typical for all forms of regulation. You start off with something which is, on any view, really important, but you then get things which are less important and possibly could be enforced in other ways. But you still have one group of people who are seeking to enforce the relevant matters. By way of just anecdote, some of you may have heard of the Putney gas explosion. The Putney gas explosion took place on the 10th of January 1985. For any of you who have a knowledge of southwest London, it took place in an estate quite close to the Green Man public house up near the Robin Hood roundabout. And what happened was that a gas main was laid over a drain with differential settlement. And in the middle of a cold spot in January, the gas escaped, tracked through the line of the gas main into the building and blew up the property. 8 people were killed and 37 flats were destroyed. It had been built in the early 1930s by John Lang. And one of the very first things I did at the bar was to be instructed, whilst still a pupil, with someone much more senior, to act for John Lang. The writ was issued on the day before the Latent Damage Act 1986 came into force in September 1986, which would have introduced a 15-year long stop in relation to the relevant period. And we sought to take the more meritorious point that out of the 137 claimants on the writ, 41 of them had been left off by accident from the body of the writ, although they were described at the header. And we didn't get very far with that. And so the action proceeded forward to a trial where we produced a witness statement from John Lang, who was then the chairman of the company, who said that he remembered the building of the property in the 1930s. He'd only just started his career, and he couldn't remember the precise laying of the trench in issue, but he did know that Bob was the foreman, and Bob would never have allowed the gas main to go over the pipe because that would have been absolutely and completely outrageous. And it follows that it must have happened at some subsequent date, possibly as a result of bomb damage during the Second World War and so forth. The point, however, is that I was sent down with a then article clerk from my instructing solicitors to Wandsworth Borough Council. And somewhat to our surprise, we discovered absolutely immaculate typed records of all the building surveyors' inspection of the relevant buildings, and showing that Wandsworth had been there on every occasion they should have been there, that they'd looked and seen, etc., etc. Now, I don't know if any of you have ever tried to have a look at buildings at a local authority's records for building inspections more recently, but I can assure you that the chances of finding that any time in the last, 40 years are pretty slim. And then we get to Grenfell. 14th of June 2017, 72 deaths, 256 people immediately homeless. It took just under 5 years to get the Building Safety Act. It came into force between the 28th of June 2022 and the 1st of April 2024. It consists of 171 sections and 11 schedules with extensive powers for new regulations. A new regulator was introduced, a new 30-year limitation period was introduced for actions prior to the coming force of the Act and 15 years thereafter. Entirely new liabilities were imposed on people other than the original builders. The Defective Premises Act was modified, and I might add that as a consequence of the change in the limitation period, is no longer a dead letter. And the estimated cost of the rebuilding as a consequence of the Grenfell Tower is 16.6 billion to 22.4 billion, according to the National Audit Office's report of the 3rd of November of 2024. So what does this tell us? Well, other than the fact that we got off lightly by comparison with the Great Fire of London, it tells us, it seems to me, that we had not really taken on board the lessons of history, and in particular, we had not considered the central provisions which are necessary for fire prevention. I want to look, first of all, at statutory control, and then look briefly at the common law. The Defective Premises Act came about as a result of the Law Commission's 40th report, which reported on the 16th of November of 1970. There were 5 commissioners, one of whom was the then Mr. Justice Scarman and Neil Lawson, who was still at the bar. The report was 29 pages long and had a draft bill, that draft bill essentially being the Defective Premises Bill. And paragraph 3 of that report is interesting. The proper development of the tortious liability for the narrower range of dangerous defects may have been inhibited by the erroneous belief that this would necessarily entail an extension of the contractual liability for defects of qualities. That's what the Law Commission said in their 40th report. It was passed on the 29th of June of 1972, and it was a private member's bill introduced by the member for Barons Court in Hammersmith. As I've already said, the principal problems of the Defective Premises Act were the 6-year limitation period and the provisions in relation to Section 2, the approved scheme. Then we have a look at the common law. Now, for those of you of a certain age where Murphy had not come forward, we were brought up on Dutton and Bognor Regis UDC. This is one of those cases where Lord Denning was in the majority, and he sat with Lord Justices Sachs and Stamp. He did reserve judgment in the case, but even so, he started the judgment in characteristic fashion. His introduction to the case started as follows. 1, the facts. In Bognor Regis, there was years ago a rubbish tip. It was filled in and the ground made up so that it looked like the land next to it. You would never know that there had been a rubbish tip there. In 1958, a builder, Mr. Holroyd, who called himself the United Building Company, bought all the land in that area and proposed to develop it as a housing estate. He called it the Gossamer Estate and laid it out in roads and plots. One of the plots was on the site of the old rubbish tip. It was plot 28. Mr. Holroyd employed a local surveyor, Mr. Lewis, to make plans and apply for planning permission and, of course, for bylaw approval. Now, what happened in very simple terms is that the builder dug down, he found some rubbish there, he put extra foundations under the external walls but did nothing about the internal walls. The consequence of that is that there was differential settlement that led potentially to catastrophic collapse. And by then, it was thought that any claim against the builder was statute barred, and the local authority was sued. At that time, the relevant regulations were the Public Health Act 1936 and the bylaws made under it, and they provided for adequate foundations, which the Court of Appeal found were plainly inadequate. And Lord Denning then came to consider whether or not a duty should be imposed on the local authority. And after identifying, making his famous statement, which was picked up subsequently in an article in the LQR, about the difference between economic loss and physical loss, he says, "I cannot accept this submission. The damage done here was not solely economic loss. It was physical damage to the house. If Mr. Tapp's submission right would mean the inspector negligently passes the house as properly built, it collapses and injures a person, the council are liable. But if the owner discovers the defect in time to repair it, he does return it, the council are not liable. This is an impossible distinction. They're liable in either case." And he then came to consider the considerations of policy, and he put forward these considerations. First, Mrs. Dutton has suffered a grievous loss. The house fell down without any fault of hers. She's in no position herself to bear the loss. Who ought in justice to bear it? I should think those who were responsible. Second, is there any reason why the council should not be held liable? And he finds that there wasn't. And then he says this: if liability were imposed on the council, would it have an adverse effect on the work? Would it mean the council wouldn't inspect at all rather than risk liability in inspecting badly? Would it mean that inspectors would be harassed in their work or be subject to baseless charges? Would it mean they'd be extra cautious? But I see no danger here. If liability is imposed on the council, it would tend, I think, to make them do their work better rather than why worse. And then he decides that there would be no floodgates. Now, he did that nakedly as a matter of policy. As we know, that was followed by the decision of the House of Lords in Anne's, 7 flats and maisonettes in Devonshire Road, Wimbledon, foundations 2 foot 6 deep rather than 3 foot, damage was 1970, judge found the action was statute barred, and the House of Lords found there was a duty and there wasn't a limitation problem, and it found that there was a present or imminent threat to health and safety, and the consequence was that there would be recovery. Murphy and Brentwood, 26th of July 1990, essentially the same. House bought in 1970 on fill with negligently approved foundations, and each of the speeches of the House of Lords emphasised that in what was essentially a consumer protection field, deference should be paid to Parliament and the DPA, and the importance being emphasised of loss being essentially economic, so that liability could only accrue to a local authority in respect of latent defects which caused damage to other property or to health and safety of individuals. Now, it is that common law background which informed the 30 years during which the cladding was put up on local authority buildings, and which is going to cost society as a whole some £20 billion or so to replace, and which, rather more importantly, led to the deaths of 72 people in Grenfell, and also caused the massive disruption to the law of this country, and led to us being considered the Wild West. And I want to consider with you what we professional indemnity lawyers call the counterfactual. I never quite understood who first introduced that. I mean, it's a horrid term, but I mean, you can't go through a con these days without someone saying about the counterfactual. Anyway, Lord Denning was right. Local authorities should have been liable for economic loss caused by dangerous defects. Local authorities consequently regulated better, whilst also ensuring that claims against builders were available. The Limitation Acts were revised. The Defective Premises Act was not a dead letter. Combustible cladding was not permitted. There was no Building Safety Act and no £20 billion bill. Can I just say something about the building regulations 1985 and 2010? Those regulations, as a matter of philosophy, adopted a different approach to the building regulations in 1965 and their manifestation up until 1985. They decided that they were going to set out standards to be achieved rather than detailed provisions. In their initial form, that meant that they were 29 pages long rather than 206 pages long at the time of 1985. They subsequently grew. You had approved documents which identified how you could do things, but they gave as general aims things like fire spread shall not go across the buildings, which is a bit like saying that we approve of motherhood and apple pie. It was the case that the Grenfell report and others have said that Grenfell was built in breach of the provisions of the building regulations, because essentially fire spread was permitted. But it was not the case that there were any prohibitions on use of particular materials, including obviously deleterious materials, which were banned in most, not all, but most of the rest of the civilized world, and often in situations where buildings were above a particular height. And so what we see as a lesson from history is that when you get a fire, the Great Fire of London, you get a burst of regulation, you get enforcement of that regulation, you then go through, you mix in that regulation with other things. In due course, people start saying you're regulating too much, and you decide to make everything rather less expensive, and then you need to learn the lesson again from history. I would venture to suggest that the common law, if you had a position where people were able to sue local authorities and indeed original builders for defects in quality, which led to danger, that would be more likely to achieve the objective which we all want, viz. People not being burnt to death and massive economic damage, and at substantially lower cost than the regulations which we have endured. I want now to move on to my favourite subject, auditors, and I should say for the audience now, some of my best friends are auditors, so you know, or you should assume that anything I say about auditors is well, they're obviously just jokes. Now, I don't know how many of you are familiar with the FRC, but the FRC came into being followed the Deering report of 1988. Sir Ron Deering wrote two reports, and it's easy to get them mixed up. One was about the accounting profession, and the other one was about funding for universities. We're talking about the Deering report concerning accounting standards. And he recommended the creation of two new bodies, the FRC and the Accounting Standards Board. And the purpose was to improve the quality of financial reporting and increase the level of regulation. And it was formed in 1990, following his report, by the amalgamation of 6 previous bodies. As has been pointed out by lots of people, the accountants have managed to retain regulation by the profession of the profession. And whenever there is a proposal for reform, what you find is that the old boy and old girls network, who start out from PwC and Deloitte's and so forth, get in contact with all their people who are now working as civil servants, general counsel and so forth, and say what an appalling idea it would be if anyone outside the accountancy profession who doesn't understand the full difficulties were to be involved in external regulation. It has been, it's fair to say, the subject of really pretty sustained criticism. Sir John Kingman, another man who has a sort of career, he wrote 2 other reports, but the relevant one was his independent review of the FRC in 2018. He was quite mild-mannered. The FRC powers were clearly deficient, excessively consensual approach to its audit, and this bit I quite like, reliant on the alumni networks of the largest audit firms. The criticisms related to the failure to follow up on concerns as to Carillion's accounts, that was in 2015, no action in relation to HBOS, and there was also a problem about lack of transparency and accountability. There was a particular concern that the FRC had inspected Grant Thornton's work on the accounts of Patisserie Valerie in January 2018, 6 months before a £40 million fraud was discovered, and they didn't actually bother to tell anyone that they'd done that for some year after the report was instituted. The Competition and Markets Authority, April 2019, on statutory audit services, recommended an operational split between audit and non-audit, mandatory joint audits for the FTSE 350, and scrutiny of company audit committees. Sir Donald Brydon, in April 2019, recommended the urgent establishment of the Audit Report and Governance Authority. That's going to, I'm sure, sort out all the problems, and a fundamental shift in definition approach of the UK audit industry. So far as the FRC is concerned, the current position is that in 2025 to 2026, it has a budget of £72.3 million and 506 employees. It opens 70 matters in the year to 2023, 40 in the year to 2024, and 40 in the year to 2025. 8 investigations were started by the Conduct Committee, and there were financial sanctions of £14.5 million compared with £48.2 million the previous year. Now, the FRC itself publishes figures showing that the Big Four audit fee income for 2024 was £3.676 billion, and the total income, that's for all of the accountancy firms, was just under £5 billion for essentially public companies. And the revenue from audit was about 23% of the Big Four's income. The fines for the relevant year are accordingly 0.3% of the audit revenue and provide no compensation to any victims. Now, anyone who's been involved in the work of either acting for or acting against the FRC will probably be aware that their prosecutions aren't necessarily always conducted as competently as they might be. But the bigger and more fundamental point is that the FRC is singularly failing to achieve its objectives of actually getting better audit results. And I do not believe for a minute that some other regulator with other powers and bringing it all together is going to achieve that end. I also think that it is completely obvious that only having 4 large audit firms is a real problem in competition, particularly if you require auditors to be changed fairly regularly. And you should require auditors to be changed fairly regularly, because otherwise you get the inevitable effect, which is that the auditors become much too close to the management. The present position is that a draft audit reform and corporate governance bill was announced in July 2024, but in July 2025, the government announced it wouldn't be introduced this session. The present word on the street is that it might be introduced in the 2030s. All those old boys and girls sitting in the departments saying, I don't think this is a priority. I really don't think this is a priority. The proposals of the bill were extending the FRC's remit to large private companies, stronger enforcement powers on directors, new reporting requirements, and market oversight of the Big Four. I mean, what on earth do you need to know about the Big Four and market oversight that anyone with any kind of basic degree in economics could not tell you? It is obvious we have got too few accountants. We don't need too few big accountants. We don't need any further reform in that respect. Now, these are my more mild-mannered questions. Will a new regulator really change audit behaviour and restore public confidence in audits? Audit fees are a significant cost of incorporation. Just on this, the largest audit fee reported in 2024 is HSBC's fee for its audit of a modest £88 million for its 2024 audit. Now, just think about that. What could you do with £88 million? What could you do with £88 million which was better than paying it to PwC? I just put it out there. Are these fees being paid only to benefit shareholders as a body? The reason I ask that question is that is the predicate upon which Caparo is based. Or are they actually being paid in order to allow companies, such as banks, to deal with others and to allow investments to be made with confidence? And then this question: would the quality of audits improve if liability of third parties were greater and regulation costs cut? Well, you can take your own view in relation to that particular matter, but my suggestion, ladies and gentlemen, is that the likelihood is that they would be. I'd also suggest that deference to Parliament and to regulation in this particular field is misplaced for some of the reasons that I have just identified. And so my overall theme is that if you go back to the questions which I asked and dealing with this tiny aspect of regulation and its influence on the economy, we would do better if we were rather bolder with the ambit of the common law, rather less concerned about the restrictions in scope of duty and so on and so forth. And that would be likely to make this country a better, more efficient and more prosperous place. No, well, I'm sorry, that means you're going to have to go to lunch early. Or whatever it is. No, I think you've got another talk. But thank you all very much indeed for attending, and I look forward to seeing you next year.